Thank you. Before he got here. Yeah. But yeah, he does like it. Yeah, he like it.
I could go down and snap.
Check 1 2 1 2 3 4. Check 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 1 2 1 2 3 4. Check 1 2.
Testing 1 2 3 4. Testing 1 2 3 4. A B C D F G. Testing testing.
Yeah. Well, all the T-balls that they wanted. Those things are everywhere. Okay. Not a fun time. Yeah, they're just cash flowing everywhere. Just bags of cash walking out years ago. Yeah.
Yeah, these are all for just but I think the open feature is over there. I think, but I don't know anything, honestly.
Yeah.
Like, I don't feel comfortable finding. I gotta say. got the name tag. I did get it.
A couple from You're not going to see anything. It's just the people and who you're talking to. Right here. You've already talked to this spirit. You know what. Yeah, they do opening remarks. That's what. Yeah, and like they could, who knows how long that goes.
How it's like. He gave me everything.
So, no. You're gonna be great.
Oh, thank you.
I'm okay. I'll probably choke on
Do you ever think Rich looks like Ben Roethlisberger? Do you ever get that? I can see
The beard?
Ben. Yeah,
The beard?
yeah.
Oh, yeah.
No, you're fine.
My girlfriend is streaming it already and said she can hear us. He was the budget guy.
That's right.
I was telling Megan whenever we left Hudson, so Hudson walked with me the whole way. And like I was talking to him, I think he's like actually in and really is supporting it. Like in terms of everything we're doing, he hasn't been as outright saying it, but like it was pretty genuine. It was a good conversation. I was interested that he walked with me the whole way too. Like yeah. Well, I think it's because it's getting traction too.
Yeah. Yeah. Oh, sorry. Yeah, sorry.
Yeah, you want to get in it?
Sure.
As well?
Ma'am, very well.
Looks good with the background. Be tight. Rich smiles. Tell him to smile.
Oh, still going?
I
Sorry.
get one of you too.
Oh, sorry. Thank you.
So, as far as reaching out, they look up to you.
We wouldn't.
Same position.
Yeah, if you can get the whole
seal.
thing, that's pretty cool.
Yeah.
And now I kind of do very light.
Yeah. Yeah. Well, he always, like, when he
I
does
mean, they
interviews,
can always
he's
come in.
Yeah, talk to her about all the medical stuff because she just understands it and she likes it a lot. Because I do. I really like her.
Who was it that mentioned that they could do
my caller. And then he does
normally they can be like dual committee hearings? We're doing the same. Yeah.
Oh, thank you. I decided if we're gonna go bold, we're gonna go.
Oh, I love your color and everything. By the
Thank
way.
you.
Way to do it up.
Thank
I
you.
love it.
Well, and with representing the service women's action, I was the color is red.
Oh.
So I was like,
And you look good in red.
thank you.
I love red lipstick. My mom said today, she said to me, don't wear red lipstick. Fine.
I would say go for it.
Lipstick.
Yeah, it looks great.
Oh, right. I was like looking at your lips like, me right now. Never
It's
listen
like,
to
of course, I know my husband's gonna be out of line. Like, why is she wearing red lipstick? He hates red lipstick. Yeah, yeah, but no, it's one of those. I'm like, I'm finally getting her. I'm gonna be bold and just
Good for you.
stand
I
out.
love it. By the way, I love this piece too.
Thank you.
It's all together.
It's all White House Black Market.
I love
They're
it.
my go-to.
My best friend from law school is White House Black Market. It's all she wears.
Yeah, I love it. It's just so, and it's so helpful. Like every time I go in there, I need to get some new suits, which I have a child that was supposed to be starting last week, but that continued. And I needed some new suits, and I walked in, I'm like, I need suits. And they're like, just snap what size, and they put a bunch of them. So much nicer, because I don't have to go and find all the pieces that coordinate it, and they have to put different glasses and stuff. So much easier.
What area of practice?
Aviation law.
Oh, that's right. You said that.
Yeah.
Okay, so you're kind of the defense side, right?
Yes.
Okay. I had someone looking for an aviation lawyer, and I said, I don't know any.
Let me give you my card.
So it's fully loaded with turkey shot now. I'm nailing it. And I figured
The slogan is
there's
good.
nothing more appropriate.
Yeah.
I come there and tell all the neighbors that the special forces man nailed King Kong because nobody else could get him. So how have you been?
Good.
You look great.
Trying. Thank you.
You look wonderful.
Trying. Take the medicine, she don't have to do stuff. So.
That's great.
Are they
I'll send you an email and connect you guys.
recycled?
Great. Oh, yeah, that's a great.
Yeah, and I have a wide range of meat pretty much.
Yeah.
Make sure I'm drinking my water.
Right, I know.
No.
I just want to make sure everybody's kind of comfortable with the microphones and the timers. So this is what it'll look like when your microphone is on. So we'll turn it off.
Good afternoon. This hearing will come to order. I want to welcome everyone to the Military Personnel Subcommittee of the Armed Services Committee on a hearing that we're having today on what has been dubbed the Feres Doctrine on military personnel and the prohibition of active duty service members from bringing suit against the U.S. government, specifically for medical malpractice. Feres is the product of judicial activism and Congress's silence. As no less an authority than my favorite Supreme Court Justice, Antonin Scalia, said, quote, "There is no justification for this court to read exemptions into the act beyond those provided by Congress. If the act is to be altered, then it is a function for the same body that adopted it," unquote. The court overreached, and Congress's response is long overdue. Today, we have a panel to help inform us of the issues surrounding the Feres Doctrine. Our first three witnesses are pained victims who have been aggrieved firsthand by the outdated judicial doctrine. I want to thank you all for being here. You are representing yourselves, your families, and countless others, despite what you've lost and will lose. Your commitment to fixing this policy is admirable and greatly appreciated. Our first witness is Sergeant First Class Richard Stayskull, whose radiologic diagnostic test was misread at an Army treatment facility and who currently has stage 4 terminal cancer. Sergeant Stayskull, I want to take this moment to thank you in particular because of the malpractice you suffered. Your time is numbered in days and weeks, not years and decades. I know you'd rather spend this time that you have left with your family and loved ones closer to home, not here at Congress, but I'm greatly indebted to you for doing so. You have moved me by the conversation we had months ago, so much that I felt compelled to hold this hearing today. So I know you're here not because I invited you, but because your commitment to your fellow service members runs so deep, your desire to achieve justice for them so profound, that you continue to look out for them as best as you can and as long as you can. And I promise you that we will all remember your commitment, your honor, and your sacrifice, and that I will keep working on this to fix it as long as I am here. Our second witness is Ms. Alexis Witt, the widow of Air Force Staff Sergeant Dean Patrick Witt, who was hospitalized in 2003 for what should have been a routine appendectomy at Traverse Air Force Base in Fairfield, California. Following surgery, a nurse administered a lethal dose of fentanyl, causing respiratory and cardiac arrest, and incorrectly inserted a breathing tube into his esophagus, depriving his brain of oxygen. Staff Sergeant Witt remained in a vegetative state for 3 months until Ms. Witt removed his feeding tube. Our third witness is Miss Rebecca Leip, a former judge advocate for the Air Force who now practices in the civilian sector, who while deployed in Iraq had to wear ill-fitting, MacGyvered body armor that caused her debilitating abdominal pain. Military physicians repeatedly misdiagnosed and mistreated her, making the problem worse and causing chronic pain and permanently damaging her reproductive system. These three witnesses represent the countless hundreds, if not thousands, of victims denied justice over the 69 years the Feres Doctrine has been in place. I hope to learn more about the malpractice the three of you have suffered and how the Feres Doctrine amplified the harm. The families of Feres victims, both here and around the country, suffer too. They lose loved ones in the prime of their lives and are left with a one-size-fits-all compensation system that cannot hope to adjust for the damage done in severe malpractice cases. When our service members suffer from medical malpractice, when doctors fail to perform or woefully misread tests, when nurses botch routine procedures, when clinicians ignore and disregard pain, service members deserve their day in court. When lives are disrupted, ruined, and cut short by negligence, service members deserve a chance to receive just compensation. We're not talking about special treatment. We're talking about giving service members the same rights as their spouses, federal workers, and even prisoners when compensation schemes are insufficient, when administrative redress processes fail. Service members should have their claims heard in the justice system under the Federal Tort Claims Act. And we are not talking about service members who, in active duty, are in combat. We're talking about service members who are here in the United States or elsewhere, not in a combative role. In our country, we rightfully revere service members for their bravery and sacrifice. It is disrespectful and shameful that for 69 years, Congress has refused to give them the same rights as everyone else, or just the same rights as the rest of their families. But this isn't just a matter of justice, it's a question of accountability. Because behind the shield of Feres, DoD's health providers act with impunity. We've heard countless stories from service members of procedures, big and small, botched in ways that are always frustrating and occasionally catastrophic. Gauging the full extent of this problem is difficult, but ask any service member you meet or their family, and they'll have a story. Allowing service members to sue the Department of Defense for medical malpractice will help root out this rot. There are few incentives better than the threat of legal action to push an organization to change its behavior. This would lead to better quality care for our service members and higher levels of readiness. We will also hear from two legal experts who have studied the Feres Doctrine. We look forward to gaining a better understanding of the legal foundation for Feres and why it has remained in place for 69 years just because the Supreme Court decided to legislate and Congress has sat back idly. We would like our legal experts to share any recommendations on how the Feres Doctrine may be changed in ways that respect the unique nature and needs of the U.S. military. The legal experts on our panel are Dr. Dwight Sterling, Chief Executive Officer of the Center for Law and Military Policy, a think tank dedicated to strengthening the legal protections of those who serve the nation in uniform. Dr. Sterling is also a Reserve JAG officer in the California National Guard and co-founder of Veterans Legal Institute. Also joining us is Mr. Paul Figley, Professor and Associate Director of Legal Rhetoric, American University, Washington College of Law, that has published on the defense of the Feres Doctrine. Before hearing from our panel, let me offer Ranking Member Kelly an opportunity to make his opening remarks.
Thank you, Chairwoman Spear. I want to thank each of our witnesses for being here today. I particularly want to thank Sergeant First Class Daskell, Ms. Witt, and Ms. Light, who graduated from the same law school as I did, and for your service to our great nation. I wish to extend my profound sympathy for what each of you has gone through and are going through. No one should have to experience what you have experienced. Our service members who sacrifice so much deserve the best medical care that we can provide, and we as an institution let you down. I'm glad that you're able to tell your stories here today and bring public attention to this very important issue. But the unfortunate reality is that the Judiciary Committee, not the Armed Services Committee, has jurisdiction over this issue and should be holding this hearing instead of us. I encourage our colleagues on the Judiciary Committee to do so and to have an open debate on this issue that impacts our brave men and women who serve this great nation. But even if the Feres Doctrine is changed, we know it will not make you or the other victims of military medical malpractice whole. We know that nothing can take away the profound wrongs that have been done to you. Therefore, we must focus on preventing these mistakes from happening again. My primary concern is to make sure that the failures you experienced in the military medical health system do not happen to other service members. The quality of care in our military health system is something that is squarely within the jurisdiction of this committee. In reading through the written statements of Sergeant First Class Daskell, Ms. Witt, and Ms. Light, it is clear that the medical malpractice in these cases was not isolated to just one doctor. For example, Sergeant First Class Daskell visited multiple doctors and the ER on several occasions, and not one of those doctors correctly diagnosed his cancer. In Ms. Light's case, she was treated in a combat zone, then at Landstuhl, then back in the United States before anyone found her source of pain. These repeated failures, which occurred at military medical treatment facilities all around the world, indicate systemic problems within the military healthcare system. Based on the language of the 2017 NDAA, The military health system is currently undergoing the largest reform in a generation. This includes standardizing patient experience, improving quality of care, and increasing access to care. Reforms that are essential to fixing the types of issues highlighted by your cases. However, there are aspects of the Defense Department's reform plan that deserve great scrutiny. The services are contemplating a reduction of up to 20% of uniformed medical personnel. The Defense Department is evaluating whether medical facilities should be closed down, and many service members and beneficiaries are concerned. I fear that these changes may damage the military health system and that these profound changes will happen without proper oversight from Congress. That is why I've asked for this subcommittee to hold a hearing on the status of military health reform. In addition, the Military Coalition, a consortium of organizations representing 5.5 million service members, veterans, their families, and survivors, recently wrote the subcommittee urging the committee to hold a hearing on military health reform. Madam Chairwoman, I ask that the Military Coalition's letter be made part of the record.
Without objection?
I urge the subcommittee to have a hearing on military health care reform prior to the National Defense Authorization Act markup so that members can address these important issues. While I look forward to hearing from each of the witnesses today to discuss the Feres Doctrine, I also want to learn more about your medical experiences and what we can do to make sure that these failures don't happen to any other service members. With the military health care reforms currently underway, we have a rare opportunity to fix many of the problems that you encountered. So I look forward to your testimony, and I thank you for discussing this very important subject. With that, Madam Chairwoman, I yield back.
Thank you, Mr. Kelly. I ask unanimous consent to allow members not on the subcommittee to participate in today's hearing and be allowed to ask questions after all subcommittee members have been recognized. Any objection? Without objection. Each witness will have the opportunity to present his or her testimony, and each member will have an opportunity to question the witnesses for 5 minutes. We respectfully ask the witnesses to summarize their testimony in 5 minutes or less. Your written comments and statements will be made part of the hearing record. Also, we had hoped to have Professor Andy Popper of the American University's Law School testify today. Though personal issues precluded his participation, I would like to ask unanimous consent to enter his article on this subject into the record. Without objection, so ordered. With that, Sergeant First Class Daiskell, you will make your opening remarks. Thank you so much again for being here.
Chairwoman Spear, Ranking Member Kelly, and members of the subcommittee. I'm grateful for your support, Chairwoman Spear, and thank you for the opportunity to appear here before you today in the subcommittee to present my story. I very much appreciate being invited to testify about the Feres Doctrine. This is the first time I've ever been called to testify, and I wish it could have been under different circumstances, but nonetheless, I feel this is an important issue to address. I feel this is a very important issue to the military community that requires congressional intervention to address and fix how this mistaken doctrine is used to strip hundreds of service members like myself and their families of the same rights that the rest of the citizens of our country have when it comes to medical malpractice. By way of introduction, I served as a Marine for 4 years and am currently serving as a Green Beret in the United States Army Special Forces, stationed at Fort Bragg, North Carolina. I've devoted my entire military career, with this June marking my 17th year of service. I first enlisted into the United States Marine Corps in 2001, served as a machine gunner and a scout sniper for 4 years. During my 2004 tour to Al Anbar province, Almaty, Iraq, I was critically wounded in action by heavy insurgent sniper fire. Following my recovery, I was honorably discharged from the Marine Corps. By 2008, I had joined the Army and become Special Forces. I was assigned to the 10th Special Forces Group, Fort Carson, Colorado, and later assigned for Special Warfare Training Group. I've been on multiple deployments throughout areas of responsibility and support of national interests during global war on terrorism. I've held numerous positions throughout my military career. I was selected by the Army Special Forces Group to attend Special Forces Underwater Dive School, Combat Dive Qualification Course, CDQC. Because of my previous gunshot wound, it was mandatory that I could not attend this school without having a CT scan done of my lungs to ensure the safety of myself and other divers within the course. And the imaging was done, my physical went forward, and I was cleared in January. I went down, a civilian had reviewed my scans and cleared me to go, and I went down to school. Until about 6 months later, I found out that Womack Army doctor failed to identify an abnormally over 1.5 centimeter large tumor located in the upper right lobe of my lung. While attending dive school around the end of March 2017, I was experiencing difficulty breathing, and by April 2017, I'd begun noticing signs of declining health, something I'd never experienced before in my career or life. I was wheezing, coughing, had difficulty breathing. Anytime I'd lay flat on my back, I felt like I was suffocating, and the weight on my chest was unbearable. I had also begun coughing up a bit of blood at this time. And typically, I'm not one to complain. My training doesn't allow it. We continue to work without complaint. I started to express my concerns to my wife, Megan, and my coworkers. Finally, I had enough. I had to admit myself for help. I went down to the SWIT clinic to seek treatment, and they called an ambulance and sent me down to the Womack Army Hospital. As I was wheeled into Womack Army Hospital, I went straight through the triage room and went out to the waiting room where I was placed to wait with everybody else. By the time I saw the nurse and she had taken my vitals and I had told her my symptoms and signs, she pretty much told me there's no way I could be in serious pain or any kind of discomfort due to my age and my condition of my job. She pretty much just disregarded it. By the time I went back and I saw the ER doctor, he had ordered an x-ray, reviewed the x-ray, and said it was probably walking pneumonia. So he did a couple breathing treatments and sent me on my way. Later that week, things continued to progress. By 1 week later, May 22nd, I was back into the ER. This time, I was calling my wife. I called TRICARE. I called the Army Hospital. I begged and begged and begged for somebody to see me, and I knew something was wrong at this point. My vision was going out. I couldn't concentrate, and I couldn't see. My commander, not wanting me to go back to Womack Army Hospital and suffer the same thing, put me in my car and had somebody drive me out to meet my wife in town. By the time I got out there, I was practically unconscious. My wife picked me up along with a friend, put me in a wheelchair, and they wheeled me inside. While I was waiting to be seen, I completely passed out at this time. They took me in the back where I was told a nurse did a sternum rub on my chest to bring me back and wake me up. From there, I did more treatments, and the ER discharged me with potential walking pneumonia and gave me prednisone. They didn't find anything either. It was also stated that when I left Fort Bragg Army Womack Hospital, that something had been seen and it was noted, but they didn't tell me what it was or what condition it was, that I was just to wait to follow up. By the time I had been seen out in town, 6 months had passed by. The tumor had doubled in size, 2.8 by 2.2 centimeters was present on my upper right lung, and the CT scan showed a follow-up that should have been scheduled for me. Like I said, nobody ever told me. It wasn't until finally my commander went down to the hospital and demanded that I either be seen or released to go off post. At that time, the officer in charge said it was fine, I could go off post. He released me, but yet again, it took within the system several weeks for me to get off post and be seen. Once I was off post and seen, immediately the doctor called me within a matter of a day, told me I needed more scans and I needed to bring everything in that I had. I brought that all in. Within 2 more days, I was seen, did a breathing treatment test, and then the last question he asked me, he says, "Have you been coughing up blood?" And I said, "Yes, I have." He says, "You need to go downstairs immediately and do a scan." He called me within the next day and said, if I could have you in here tomorrow for a test, I would, but I have to wait till the following week. So the following week, I went in, and I had a biopsy done on my lung, and when I woke, I was woken up to my wife crying and learning that I had, at the time, stage 3A lung cancer. This life-changing news that it could have been addressed nearly 6 months earlier, while the cancer was still contained to one area of my lung, is inexcusable. Later, around Christmas of 2017, I began to cough up more and tremendous amounts of pain. By the beginning of January 2018, I had to go to the ER where I was seen again for exhibiting difficulties breathing. This was an overall physically painful time due to my cancer spreading throughout my body. I eventually did a PET scan, and the PET scan revealed that my cancer had been metastatic and had spread. It now was in the left side of my neck and my lymph nodes, my spleen, liver, ilium crest, spine, and right hip joint. Beginning on January 22nd, 2018, I was diagnosed stage 4 terminal. The failure of the military's doctor's gross negligence and failure to detect my cancer when it was first noted on the CT scan done on me in January 2017 is a mistake that allowed an aggressive tumor to double in size and rob my life and my life of my family without any recourse due to a 1950s Supreme Court case created the Feres Doctrine. Because of all that has taken place, I am no longer able to complete the warrant officer course, which I was selected for, and I'm now currently being separated due to a medical discharge. I've endured countless CT scans, MRIs, PET scans, radiation, chemo, spleen biopsy, lung biopsy, as well as surgery to remove my upper right lobe. I've had countless other procedures and no end in sight. Lastly, I want to say that this does affect me, obviously, but my children are definitely the true victims, along with my wife. The hardest thing I have to do is explain to my children when they ask me, this doesn't make sense, how is this happening? And I have no good answer to give them. And I say that's why I'm coming up here, to help convince these folks in Congress to change this. This doctrine has effectively barred hundreds of service members and their families any chance to be made whole for receiving negligent medical care that is given by the government provider when service members are on active duty, regardless of whether injury was the result of combat service or deployment. The doctrine has been utilized by branches of military to shield negligent medical care given by military providers. This is medical care in which there is no element of military judgment. In truth, the only difference between a military provider and a civilian provider is the military provider wore fatigues to work that day, and his or her patients do not have a choice accepting their services. This is why I'm up here today, to call upon you folks to hear our cases and hopefully make a change within Congress and legislation. I want to thank again my attorneys, Natalie Quam and Daniel Maharaj, and again my family, and again Chairwoman Spear, Ranking Member Kelly, for holding this and hearing my story.
Sergeant Saskel, that was profound testimony. Thank you so very much. Ms. Witt.
Thank you, Chairwoman Spear, and to the members of the subcommittee for the opportunity to speak today. As you know, and as you mentioned earlier, in October 2003, my husband, Staff Sergeant Dean Witt, underwent a routine appendectomy. The nurse anesthetist was faulted for having administered a lethal dose of fentanyl, resulting in respiratory and cardiac arrest. She failed to call code blue, used pediatric equipment for resuscitation, and misdirected a breathing tube. Each mistake delayed critical seconds, and Dean suffered severe brain damage and remained in a vegetative state until I removed his feeding tube 3 months later. I later filed a wrongful death suit, but my case was dismissed on the grounds of the Feres Doctrine. 69 years ago, the Feres Doctrine was wrongly decided by the Supreme Court because it leads to not only medical malpractice, but also the abuse of power, mistreatment of survivors, lack of transparency, and lack of accountability. After the malpractice incident, and while my husband was still in the intensive care unit, I met with 2 JAG officers, a death casualty officer, Dean's major, and first sergeant, to discuss permanently retiring Dean. I was outnumbered, I was alone, and I was without legal representation. I knew signing these documents was serious, but I didn't understand all the implication or consequences it would impose. In my distress, I told the JAG officers I preferred to wait. I was threatened with the removal of my medical benefits and Dean's pay frozen until I signed these documents. Later, I would learn that the rush to have Dean retired came down to eligibility of survivors' benefits, as active duty death benefits differ from retired benefits. I was also told a formal investigation would take place and would result in changes to safety protocols within the hospital to prevent another tragedy from occurring. When I asked about the details of these safety measures and for a copy of the investigation, I was told that the information was protected by Title 10 of the United States Code. would not be made available to me or to anybody in the public, and I would never fully know what happened to my husband in the OR. The nurse responsible for my husband's death was also responsible for the death of another airman just 1 year prior. A colleague had stated she was considered the weakest link in their department. Despite her performance as being merited as unsatisfactory, no preventative measures were taken to curtail her advancement, and she went on to kill 2 patients. If the appropriate action had been taken on this nurse during her first lethal negligent episode, Dean would still be alive today. Before I end my time today, I'd like to discuss one last topic that is delicate in nature, and I don't want to come across as indelicate, but it's a matter worth mentioning because it affects all survivors that are affected by the Feres Doctrine. It comes down to survivors' benefits are often cited by the opposition as the reason not to move forward with the Feres reform. Military law expert Eugene Fidel has quoted survivor benefits as being robust, yet they do not take into account pain and suffering. These benefits also come with restriction, whereas an award settlement would not have such restrictions. To name a few of these restrictions and what I experience each year, I have to sign a certificate of eligibility form proclaiming that I have not married in the past year. I have to do this twice a year for each of my dependents. SBP and the DIC offset cut $65,000 spouses out of nearly $12,000 a year in compensation. The SBP is an insurance annuity and DIC is a VA benefit, but they count against one another when they shouldn't. If the survivor remarries, he or she forfeits the VA benefit. There are also earned income restrictions. With the DIC, I cannot take a job that would go over $8,000 a year. The Department of Defense survivor's benefit is taxable. The SBP is treated the same as a trust or estate, which means minor children can be taxed at a rate as high as 37%. The Department of Veteran Affairs dependency and indemnity compensation is not taxable. With an award settlement, the IRS does not tax award settlements for personal injury cases or wrongful death cases. I hope my experience with the Feres Doctrine has served a higher purpose and gives you a well-rounded view of its effects on our military and their dependents. And thank you for holding this hearing, and thank you for listening.
Thank you so much for your testimony. I think we have struggled for a long time on the issue of widowhood and the compensation issue, and it's one that has to be fixed. But you've raised some other additional issues that we'll get to during the rest of the hearing. Thank you so much. Ms. Leip.
Madam Chairwoman, Ranking Member Kelly, honorable members of the subcommittee, my name is Rebecca Leip, and today I have the unique privilege to speak to you as a disabled Air Force veteran and a representative of the Service Women's Action Network. My story begins in 2011 when I deployed to the Combined Joint Special Operations Task Force in Balad, Iraq. In my role as a Deputy Staff Judge Advocate, I oversaw 6 subordinate commands in their respective JAGs. These duties required me to travel around the country in full gear, which included the standard-issued ballistic vests. Now, the ballistic vests are not designed to fit a woman's body. In order for the gear to protect my vital organs, I actually had to remove the side panels and had to place foam inserts on the shoulders in order to remove some of the slack. I also was required to over-tighten the gear around my waist so that it would remain in place. Ironically, this made the gear less protective. 5.5 months into my deployment, I began having acute and debilitating pain in my abdomen. At the same time, we were withdrawing from Iraq, so there were limited resources at the medical facility in Balad to actually address my pain. However, instead of conducting an actual thorough exam, they first accused me of having an extramarital affair, which was blatantly false. Told me I must have had STDs. And this, excuse me.
Ms. Leip, take your time. Take a little swig of water if you'd like.
And then they chalked up my pain to normal women's problems. From Iraq, I was medically evacuated to Landstuhl, Germany. Landstuhl is one of the most premier hospitals in the military's arsenal. Even with the extensive resources available in Landstuhl, the doctors had determined that without any objective evidence that I had pelvic inflammatory disease, which is considered a normal, like typical women's problem. They also, without any evidence, treated me on antibiotics for malaria, which I also did not have, and decided to medically evacuate me all the way back to Hobart-Field. From there, the mistakes continued for more than a year. The medical providers at Eglin Air Force Base were certain it was a female reproductive issue and performed 2 random unnecessary surgeries on me and prescribed medicine that placed me into temporary menopause at 27 years old. This caused catastrophic hormonal depletions, organ and vaginal tissue atrophy, prevented sexual intimacy of any kind with my husband, and caused severe levels of depression to the point I was suicidal. Throughout this trauma, I was also accused by military medical professionals of malingering and making up the debilitating pain. Thankfully, though, after a year and a diligent review of my medical records by one doctor at Moody Air Force Base, my care changed. He was appalled at the previous treatment I received at the hands of the military and referred me to civilian reproductive endocrinologist and general surgeon. These 2 doctors immediately and correctly diagnosed me with sports herniation as a result of wearing the ballistic gear. The civilian doctors subsequently corrected 8 areas of my abdominal wall and attempted to reverse the effects of the unnecessary medical treatment I received at the hands of the military medical providers. But the damage was already done. I now deal with chronic abdominal pain and complications due to that medical treatment. Further, my husband and I were completely unable to have children except through in vitro fertilization. To date, we have undergone 7 rounds of IVF at the personal cost of over $60,000. Sadly, through much of this process, I continue to receive substandard care at the hands of the military. During my first pregnancy, the doctors at Andrews Air Force Base misdiagnosed an ectopic pregnancy, resulting in an emergency surgery and the loss of my fallopian tube. During our 5th round of IVF, I suffered a miscarriage and had to wait 4 days for a DNC at Walter Reed, which should have been an emergency surgery. And then after the surgery, the hospital subsequently lost the remains of our baby. During our 6th round of IVF, after I had separated from the Air Force and switched exclusively to civilian providers, I received a level of care I'd never received while on active duty and was able to deliver a healthy baby girl in July 2017. This fall, my husband and I attempted our last round of IVF, but I experienced potentially fatal complications, and as a result, we can no longer have children. The compound effect of this revelation, along with the years of medical maltreatment and physical pain, took its toll, causing me to seek hospitalization once again. Now I sit before you, 10 abdominal surgeries later, as a broken but not defeated advocate for service members. Even as a JAG and experienced advocate, I had to fight hard to receive appropriate care in the medical care from the military system. The majority of other military members are not in the same position I am, especially our enlisted members, to be able to be an advocate. And additionally, servicewomen are still being issued ill-fitting gear when the technology is out there to to outfit every single female with the right gear if Congress would only appropriate the funds to do so. Members of the committee, as our champions and advocates, you can and must ensure that service members have access to and receive appropriate care from trained healthcare professionals. This includes providing the full range of women's health services in light of the growing number of female service military members defending our country. You must also ensure that the military medical providers are held responsible for their incompetent actions. Most importantly, you can ensure that service members who have suffered from medical malpractice are able to be compensated under the Federal Tort Claims Act for their injuries. No service member should have to fight as hard as I did for their health with the military itself. We have the greatest military in the world, and our medical care should be no different. Thank you for the opportunity to offer my testimony, and I look forward to answering any questions you have.
Ms. Leib, thank you for your service to our country and for your riveting testimony. Dr. Sterling.
Honorable Chairwoman Spear, Ranking Member Kelly.
Could you put the microphone closer to you?
Yes, and members of the committee. I am honored to be here today to address this important topic. I am the CEO of the Center for Law and Military Policy, a nonprofit think tank. I am also a law professor at the USC Gould School of Law and a JAG officer in the Army Guard. I recently completed a doctoral dissertation on the Feres Doctrine. My testimony today is a product of having read every case and every article that's ever been written about the Feres Doctrine, and my nearly 2 decades as a military lawyer. The Feres Doctrine is the most disparaged and discredited legal doctrine in modern history. The condemnation has been constant and vociferous and nearly universal. The critiques that are the most hard-hitting have been made by the conservatives. In particular, the late Justice Scalia and Professor Jonathan Turley. To Justice Scalia, the doctrine was simply judicial legislation. The plain language of the FTCA includes the personnel who are in the military. Yet the Supreme Court had rewritten the act to exclude them. To him, this was activism at its worst. He also condemned the fact that there was a double standard at the heart of the doctrine. It only applies to members of the military, not to their dependents or to people who are retirees. Within the military healthcare system, more than 3/4 are civilians. They are the dependents and the retirees. Yet, when a doctor does a surgery and leaves a tool in their stomach afterwards, they can sue. Or if any of these events that we heard here by my colleagues had taken place to a civilian, to a dependent, they can sue. But when it happens to a service member, they can't. If civil liability was so detrimental to the system, why isn't it banned? Why doesn't the ban then apply to everybody? Instead, it only applies to the few, to the less than 20% who are actually wearing a uniform. Professor Turley, for his part, said that the way the doctrine operates reduces the quality of care, applying a cost-benefit analysis. Government officials overuse folks who are military doctors who can't be sued, and they will underuse the civilians who are the specialists who can be sued. They capitalize on a loophole, and they limit the access to the specialists who are civilians. As a consequence, according to Turley, we are putting our service members' lives at risk. This particularly affects the young, the 18 to 22-year-olds, who are forced to receive almost all their care at a base hospital. I, as a major, and folks who are senior officers, can often get off post to see a civilian, but the junior enlisted can't. They don't have that kind of pull. The upshot of all this is concerning. While our policymakers are sending our military personnel to fight and die abroad, they fail to protect them at home. We must keep this in mind. Even those in prison can sue when a doctor makes a mistake. We're giving more rights and protections to those in prison than to those who wear our uniform. I keep having the question, does this reflect our values? I have a hard time in responding to that in the affirmative. Okay, thank you.
Thank you, Dr. Sterling. Mr. Figley.
Madam Chair, Mr. Ranking Member, members of the committee, By way of experience, I spent 3 decades representing the United States in the Civil Division of the Department of Justice in Federal Tort Claims Act litigation. For the last 15 of those years, I was second in command in the office responsible for most of the tort litigation of the government. For over a decade now, I've been in academia where I teach torts and where I write about sovereign immunity, the FDCA, and the Judgment Fund. At the outset, we can all agree that government negligence or malpractice does cause real injuries and can have a tragic impact on the lives of service members and their families. It is understandable that such people are frustrated when they perceive that they or their loved ones are being treated unfairly. From the perspective of one injured service member or one family, the remedy may seem obvious. Allow the injured service member to sue in tort. From the perspective of fostering the long-term success of critically important institution, the United States military, that remedy is mistaken. Simply put, Congress should not alter the Feres Doctrine. Doing so would disrupt the vital and special relationship between the government and its service members. That relationship has roots in the military's unique disciplinary system, its special and exclusive system of military justice, and its comprehensive compensation system. The military compensation is similar to state workers' compensation programs in that it provides a prompt, fixed administrative remedy without a showing of employer negligence or the time, expense, and emotional burdens of litigation. The military system is more encompassing than workers' compensation laws because it applies to injuries arising during a service member's period of service, not just those arising in the course of employment at the workplace. Its benefits are substantially broader than those of state workers' compensation laws and include programs ranging from education to housing to medical home improvements, lifelong care, and sexual trauma. The VA booklet describing benefits fills 70 pages. If Congress overturns the Feres Doctrine, attorneys for injured service members will litigate whether someone in the government wrongfully caused those injuries. As the Supreme Court has repeatedly recognized, the unique relationship between the United States and its service members would be undermined if exposed to our adversarial tort system. One key part of that relationship is the military's obligation to take care of its own and to treat similarly situated service members equally. Similarly situated service members cannot be treated equally if Congress overturns Feres. If 3 service member amputees share a hospital ward, one having lost a leg in combat, one suffering the same loss in a tank accident in France, and one because of malpractice by a military doctor in New York, each will have the full panoply of military benefits. The 2 who suffered their loss in combat or overseas would be barred from suing by the FDCA's exceptions for claims arising in combatant activities or foreign countries. An FDCA suit by the one injured in New York would likely recover a $1 million judgment. The other 2 service members would know it and may well feel unfairly treated. Such feelings undermine military morale and cohesion. This is not an idle concern. A key lesson of the September 11th Compensation Fund is that providing different individualized awards to members of a group who have suffered a similar loss can cause frustration and ill will. As the report of that fund's special master explained, there are serious problems posed by a statutory approach mandating individualized awards for each eligible claimant. The statutory mandate of tailored awards fueled divisiveness among claimants and undercut the very cohesion and united national response reflected in the Act. The fireman's widow would complain, "Why am I receiving less money than the stockbroker's widow? My husband died a hero. Why are you demeaning the value of his life?" Presidents Truman and Eisenhower understood this when they vetoed private bills for the benefit of single service members. President Eisenhower explained, quote, "Uniformity and equality of treatment to all who are similarly situated must be the steadfast rule if the federal programs for veterans and their dependents are to be operated successfully. For these reasons, Congress should not alter the Feres Doctrine."
All right, thank you all for your testimony. Let me start with you, Mr. Figley. Do you think allowing service members to sue the government for medical malpractice in a non-combat setting would create a worrisome number of lawsuits that you might characterize as frivolous?
No, I don't believe so.
Okay, so that would not be an issue. You also referenced the trust relationship that exists. And there is a special kind of trust that exists between the military leadership and service members and their families. There is this trust in part because there's a sense that we are family and that we will take care of you. I want to ask those of you who have suffered the losses and the medical malpractice, if you feel that the DOD's subsequent response has violated that relationship of trust. Sergeant Stayskull?
Yep, I believe it violates the trust completely. I mean, you know, when I signed up to do my job, I was told, this is your job. You will do this job. You'll do it to the best of your abilities. No questions asked. Well, I believe that when the DOD said that they said that they would provide me adequate medical care to a standard, and they failed that portion. So therefore, my trust is completely broken within, not all of them, but the ones. But then it goes back to, well, which one is it? Who knows now? They're blended in and they disappear within the system. So the trust is lost completely there. So I don't.
All right, Ms. Witt.
I have to agree with that, Sergeant Stayskull. In my particular situation, because of transparency issues, even down to making medical choices for my husband at that time, I was not first aware that he went so long without oxygen. I was only told that it was a couple of minutes and that they were just observing him until I actually arrived on the base and saw the state that he was in. He was in a medically induced coma, so I could not tell like how severe his brain damage was at that time. Had I known, I probably would not have had him suffer in his hospital room for 3 months. I probably would have taken him off life support at that time, which was a ventilation, and he probably would have been able to at least have donated his organs. And that affects like 10 other people in the world that were probably waiting on those organs. So that trust right there was lost because I couldn't even trust the medical providers who were providing him with care.
You know, Ms. Witt, we have very similar experiences. My first husband was on life support, and that's exactly what I was concerned about, whether or not I would be able to donate his organs. So I totally understand what you're going through. Ms. Leip, your comments?
I've completely lost faith in the DOD to be able to take care of me. I still am actually a Navy spouse. My husband is still serving active duty in the Navy. And so therefore, both myself and my daughter are entitled to TRICARE benefits and could receive all of our care on base for limited cost. Instead, I pay an exorbitant amount of money to pay for my private insurance with my current employer because I don't trust them. I will not let them touch me or my daughter because I no longer trust that they can take care of us appropriately.
Dr. Sterling, you know, those who are proponents of the Feres Doctrine, and certainly Mr. Figley made mention of this in his testimony, suggest that depriving service members of an ability to sue is a fair trade in the circumstances given the generosity and comprehensiveness of the military workers' comp scheme. What do you think enabling service members to take legal action in malpractice cases is necessary despite the generosity of this scheme?
Because, Chairwoman, it's simply not the case. This idea that VA disability is a substitute for a lawsuit in the case of malpractice has been exposed as a fallacy by every scholar that I've ever read, except for Mr. Figley. He's in the minority. I think he's the only one who has made that kind of a contention. And the reason is this. When you apply for VA disability, you have to show that there was a cause. You have to show that there was some kind of a military act that led to the injury that you were claiming has occurred. Well, in malpractice, you can't do that because all the evidence of the cause is the negligence. You can't get to the negligence because you can't file a lawsuit. So how can you show when you are submitting a VA disability claim that because of the appendectomy, now I don't have feelings. I don't have the feeling within my fingers. It's because of the mistake that I lost the feelings. I don't have the evidence of the mistake because I can't get to those documents. I can't sue. And as we've heard, when I then am, if I'm a patient and I am adversarial to the DOD, they shut down the information. So what happens, I've seen it time and time again as a veteran advocate. When you're hurt due to malpractice and you file a claim, the claim is denied. So you don't get that claim. That simply is a fallacy, and it should be rejected, and it has been, except for everyone, except for my colleague, Mr. Figley.
Ms. Leip, you referenced a traumatic experience in terms of gynecological services within the military, and it's an issue that I have been concerned about for some time, because I worry that there aren't enough sophisticated medical professionals with gynecological training in the military. I just toured a number of bases over the recess, and talking to spouses, I heard that over and over again, that they don't diagnose, cysts, for instance. What do you think we should do in order to make sure that service members who are women who are going to need gynecological services can get the kind of care they deserve?
I think especially given the lack of service, either increase the amount of service providers who have those specialty skills in the military, or allow those service members and the spouses in certain circumstances to go off base and seek out civilian specialty. Because for example, like a reproductive endocrinologist, there's very few of them in the military. If they're not going to have one, if you're at Altus Air Force Base, they're not going to have an endocrinologist there. They should be able to seek out a civilian provider who has that. So I think it's allowing greater access to the civilian sector, which will also improve the standard of care and will allow the most up-to-date care possible.
Thank you. Sergeant Stasko, in our conversation, I would just like some clarification. I was under the impression that when you went in for your initial scan before going to dive school, that they actually noted on the results that you had a lesion and that you should be referred, and the powers that be just never followed up. Was that my error in my recollection?
Yes, ma'am. It was seen, or it was missed. It was missed in the beginning, but they noted the first time I went to the ER, they noted that it was actually seen on the first scans, and nobody ever told me and never followed up. When I was discharged from the ER also, the doctor said, there's something there, we had seen something, but we're not sure what it is, so you'll have to go see a specialist.
So the first scan actually did detect the error. Yeah. It just wasn't, you weren't informed and you weren't referred, and it wasn't until your second visit which was then to the ER, that they said that there was something on your scan.
Yes, ma'am.
And then were you referred?
Then I was referred, but by the time I had heard from pulmonology, I had an appointment that was about 30 days out before they would even talk to me. And that was what I was fighting, to call back and say, hey, I need to be seen there. And they said, well, you have to be over a certain amount of days before you can be seen off post. And new patients are not priority, existing patients are priorities. So that was where I had to keep waiting. But again, even once you're referred off post, you have to wait for the specialty referral to go through the system, and it's got to go to the provider out in town. Then they got to call you and schedule an appointment. And that time was about 6 weeks had gone by again from my first ER trip, to where it had, from that point, spread from my lung over, and that was when I started coughing up insurmountable amount of blood profusely. I mean, to the point when I was sleeping, it felt like I was being waterboarded. I couldn't breathe. I felt like I was drowning constantly.
Thank you. Dr. Sterling, in your dissertation, you reference that 2/3 of those who are provided services at military hospitals are actually dependents.
Yes.
Is that correct? And that being the case, you would think that we should prioritize our service members in terms of getting services, but it appears that these facilities are providing services first and foremost to the spouses and the dependents. So in Sergeant Stayskull's situation, he had to wait because there were all those other appointments before him of dependents. Is that correct?
Yes, yes. But what is, I think, particularly a problem is this idea that if we allow those hurt through malpractice to bring a lawsuit, that somehow that's going to cause a dissension within the troops. And I love when that kind of claim is made by someone who didn't serve, because I have served, and I know that that kind of claim is ridiculous. In fact, it plays upon the worst kind of ideas, because what it does is it takes this idea that we all are thankful for the infantry. Without the infantry, we wouldn't be here. They're the ones out in the field. And when they're hurt, it's important. But it's also important when a service member is hurt through the malpractice of a doctor. So the idea isn't which injury is more important or what one service member feel about another. It's where is liability, where should we have civil liability? There's no one, and I'm at the top of the list, who wants there to be liability in combat. That's why our Congress and the FTCA said this doesn't apply to combat. That's why the bill that's in front of the committee doesn't apply to combat. No one wants a commander concerned about his suit on the battlefield. Nobody wants that. But what we do want is a doctor to be concerned. And so, I ask, how do we know that we want our doctors to be concerned? Because in every other aspect of our healthcare system, if a doctor is incompetent, he can be sued. If we don't like the idea of liability, why do we have it everywhere else except for the military in the context of medical malpractice? It exists everywhere else except for one place, for the 1% who are fighting and dying for us. Is it the right kind of a policy to have their doctors, the ones who are fighting and dying, not concerned about a lawsuit, but every other doctor, to include the ones that do work on each of the members here, they have liability, and they do a good job because of that.
Thank you. Ranking Member Kelly.
Thank each of you again, and it was powerful and moving testimony, and I appreciate that. So, First Class Dayskull, I want to reiterate again. It's not, the problem with this is we're talking about the Feres Doctrine, and we're in the wrong committee.
Well,
we're talking about differences between equity and law and equity, or cases of equity and cases of law, dicta versus real law. And so I hope the Judiciary Committee is listening to this, because these are very, very real discussions that need to be had in a committee that can actually do something about it. We are doing something here, and I thank the chairwoman for bringing this. We're doing something because we're highlighting their need to address this. But the reality is, so Sergeant First Class Dayskull, I want to focus on what we can do in this committee on military personnel to help other soldiers from doing what the wrongs that you have been done. So, did you report any of these incidents to DOD, and what actions were taken to investigate the failures of the medical treatment?
So once my wife and I began reading back through the notes, the doctor's notes and everything, it became very evident that something was wrong. Even when I finally got to see my civilian provider out in town, he was actually the first one to go, "Why weren't you seen in January? There's clearly a mass there." And that was what sparked us, and my wife just started reading. Before we knew it, didn't make sense. At that point, I actually scheduled a meeting with the OIC of the hospital at the time, Womack. I invited my chain of command to go down there with me. They went with me. I'm not going to speculate where the commander was, but he just came off of leave. At the time, when I went to his office, explained everything that had happened to him, I was met with, "Things do happen." From there, I pretty much, it was a lot of back and forth, but there was no real answer on, there was nothing they could do, So I really got no feedback after that. That was pretty much the answer I got, sir.
I hope that you will let DOD, and hopefully that some of those guys are listening today, but I hope that you will file a complaint so that we can do some systemic things that maybe can keep someone else from doing this in the future. And I thank you for your service, both in the Marine Corps, and I actually was in the same area about a little bit after when you were there, and so thank you for your service. Ms. Light, you and I met in my office earlier today, and one of the stated goals of the 2017 NDAA military health system reform is to standardize patient experiences that service members receive excellent care regardless of where they are seen. And you've covered a little bit of those, but tell me the differences in where you've received care and you don't have any confidence in the military health care system now to care for you and your daughter. Is that correct?
Yes, sir. I've was seen at Longstool, Eglin Air Force Base, Hurlburt Field, Moody Air Force Base. I've seen at a number of in Walter Reed. Walter Reed and Longstool are one of the most premier hospitals that the military has, and have received medical malpractice in each of those locations. So it doesn't give me faith that I'm going to be listened to. Especially when it got to the point of the medical doctors telling me I was making it up and that it was in my head. That's not treating you. So I had already had the mental health issues because of the hormonal depletion, but when you have a medical provider just telling you you're making it up, you lose faith in their ability to even listen or treat you. So now I see only civilian providers, and my daughter sees only civilian providers. My husband, unfortunately, because he's still active duty, doesn't have the option to see anything but military providers, and that terrifies me.
And I think we talked about some of those things that are within that we can fix on this committee or this subcommittee, and we talked about the body armor issue.
Yes, sir.
And those are things we can fix because there's the root cause of this, and we still haven't fixed that problem. Those are things. And we also talked about the number of physicians who are capable of treating uniquely female problems. And do you feel there are enough, or do you think there are things that our military healthcare system could do so that we can better take care of our females in service?
I don't believe there are enough. For example, at Walter Reed, you have the GYNs are dual-hatted in both the IVF clinic as well as the GYN clinic. So that's one of the reasons why Walter Reed can only provide so many in IVF treatment cycles per year. They're dual-hatted and trying to serve multi-purposes where you need to have specialized care where they can focus on specific areas. If you're going to do in vitro, focus on just in vitro. If you're going to be a GYN, make sure they're the best GYNs available, and make sure there's enough of them so you're not having to see necessarily a nurse practitioner. You can see an actual GYN. We need more specialists, and we need them to account for the amount of women that are in the military. And in regards to the gear, the technology is already there. It just is outfitting it. We can look at the number of women serving in the military, and we can count what the gear costs and figure out what the appropriate level of appropriations is.
Would you agree with me that depending on the location that you are, what you need is the best health care you can get, whether that is military treatment or outside treatment? Some places that's available. Sometimes it's better in the military. Sometimes it's better on the civilian world, depending on where you're located. But would you agree we need to look at how we make sure we have the right assets, the right people with the right skills in the right place at the right time?
Absolutely. That's the only reason that I was referred to the reproductive endocrinologist who got me healthy. I had to drive 2 hours each way to see him, but it was worth it. And it was thankfully for one doctor at Moody Air Force Base who understood that he did not have the experience and knowledge to treat me, and he got me to the doctor who could.
And Ms. Witt, I understand that you've advocated for changes to patient safety when administering anesthesia. What changes would you make to the military medical practices regarding the use of anesthesia?
Excuse me, that's a complicated question because I'm not a medical expert, and I haven't, even though I'm in school right now for prerequisites for nursing, I don't plan on going into anesthesia as a nurse. I have advocated with medical boards to, I don't necessarily think that nurses should be doing anesthesia. I think it should just be an anesthesiologist. They're more well-rounded in healthcare. I believe that they have about 50,000 more clinical hours and experience and additional schooling in order to become an anesthesiologist. Therefore, if something happens, you have critical seconds to apply medical care to someone to get an airway opened up again if it's become closed off. And nurse anesthetists cannot open up an emergency trach to do that. Only an anesthesiologist would be able to do that.
I thank each of you three again for your testimony here today, and I'm sorry for the travesties that each of you have deserved, and I want to make that better for our soldiers, sailors, airmen, and Marine, our DOD people, and their spouses in the future. So thank you for your service, and I'm sorry. I from the bottom of my heart, I just want each of you to know it never should have happened, but let's please do what we can to keep it from happening again. Thank you, and I yield back.
Thank you. Let me clarify for everyone that this committee has full jurisdiction over the quality of medical health care in the military, and that is why we are having this hearing. I think it's very informative to all of us. And the amendment to the Federal Tort Claims Act is an amendment that I am introducing as a bill later today, and it will be named after Sergeant Stayskull. And I would like to give this to you, Ranking Member Kelly, to look at to see if you would like to join me in that bill. Next is Mr. Gallego.
Thank you, Madam Chair. I understand the current interpretation of the law is that military malpractice is an incident to military service, something that shocks me as a combat infantry Marine. Sergeant Stayskull, Semper Fi, brother. Thank you for being here today. When you were training to become a United States Marine and later Green Beret, were you ever taught that malpractice is incidental to serving in the military?
No, nobody ever, it wasn't a discussion because, when I was young in my career, you had faith in everybody. You didn't know any better at the time, but I had faith. I figured I'm serving with the best of the best everywhere I was at. So to assume that, you would need to worry about something like that just wasn't a thought on your mind, and you assumed that your command, your chain of command all the way to the top had your support and they would take care of you. And I'd also like to share with you, when I was shot in 2004, I have documentation in my records from a bandage that was stuffed to my back from the battlefield itself, wasn't found and pulled out until I was stateside, all the way back in my duty station. Never complained about it, never had an issue with it. That was part of my service. That was a part of combat, and we accepted stuff like that. Things were going to happen, decisions were going to be made. But when I walk in civilian clothes and I have a scheduled appointment and I'm seeking medical care and treatment at that point, there's no battlefield decisions at that point. It's just a standard of care that should be there.
That's right, sorry. When I joined, and even though I was enlisted, I already had a college degree, but never knew anything about this type of exception that they've found under the law. Madam Chair, some of my colleagues have told me that changing this policy would be difficult because of the high costs involved. In other words, that there is so much medical malpractice in the military that it could cost billions of dollars to allow service members the same rights as their fellow citizens. I wonder, Madam Chair, what it says about our military medical system that it's so bad that we have to actually shield it, that it could cost multiple billions of dollars to fully allow tort claims, which I think should scare us all. Madam Chair, the interpretation to Feres by multiple administrations is frustrating. This administration is worse, obviously. It is willing to steal billions of dollars from recruitment, from counter-narcotics accounts, and from crucial military construction accounts to make policy choices about what it likes. But somehow, the billions it might cost to provide a more expansive reading of the governing statute and Supreme Court decision is too expensive. The lack of moral prioritization by this administration is galling. Speaking frankly, Madam Chair, this situation we have right here is just unjust. It's wrong. Sergeant Stayskull and Ms. Witt, both of whom have chosen to spend some of this time with us this afternoon instead of their families, deserve better. I hope that there's something that we can do about the situation because the moral imperative is clear. This is unjust to our service members and their families. And with immense thanks to all the witnesses and your time and your sacrifice and your anger, I yield back.
Thank you, Congressman. Next is Congressman Mitchell.
Thank you, Madam Chair. I would join Mr. Kelly in noting that while certainly the health care of our military is certainly the purview of this subcommittee and House Armed Services, the judiciary the process by which who can and cannot sue the federal government or other institutions is, in fact, not purview of this committee. So I am confused, but since we're here, we'll proceed with discussing the.
Will the gentleman yield?
If you yield me time, make up for
Absolutely.
it, I certainly will.
We'll stop the clock for a moment. There seems to be a refrain coming from the Republican side of the aisle that is, I think, unwarranted. This is a hearing that we're having about the quality of health care in the military by service members who are not in combat situations. They all have referred to what are medical malpractice cases that indeed come under Feres, but we have every right and responsibility to have a hearing on the quality of health care in the military. And with that, I will start the clock again.
If you give me a moment to respond to your question,
Certainly
my
can.
questions, I would appreciate it, Madam Chair. The reality is, the title of the hearing is Feres Doctrine, a Policy in Need of Reform. So the reality is, if it was about health care, if it was about the provision of health care, which is currently needing, it's not working well, that would be fine, but it's not. But given we're here today, we'll talk about Feres, we'll talk about its application, because I think it's important. I will note from my colleague down the other end that it's not the current administration only that has said that this is a problem and expensive. The United States v. Johnson case was decided on May 18th, 1987. I think, Mr. Fagley, you can help us with how long the Feres Doctrine's been in place.
It's been in place since 1950.
And there's been no effort on the part of the administration to change that I'm aware of.
It comes up every few years, and I don't believe any administration has supported changing the Feres Doctrine.
I'll surprise Madam Chair by saying that I'm deeply troubled by the Feres Doctrine. I've had a chance to read the dissent from the late Justice Scalia to the United States v. Johnson case, and I couldn't agree more with his logic, with his rationale. And I'd like to talk to you about your rationale, the one you've hung on to, about uniformity. Explain to me your rationale as to why Feres should not be addressed.
My point overall is that Feres serves in a way that treats everybody in the military the same. It's not that military positions can't be sued. No government position can be sued.
Okay,
they all have immunity.
If we're going to talk about Feres and its uses and application,
yes,
and if you're concerned about variations of it based on state claims in various states, then in fact we could modify it or amend it to say they all have to be done through federal court, at which point they'd be uniform, would it not?
No.
Why?
The basic substance of the FTCA applies the law of the state where the negligent or wrongful act took place. So, California malpractice law is different from Oklahoma law. But deeper than that, if you suffer medical malpractice overseas, suit is barred by the foreign tort exception.
You've read the, I assume, I'm willing to bet you've read the Scalia
Yes.
dissent in which he was joined by 3 other justices, correct?
Yes.
And what is what response do you have to a pretty compelling argument that Feres simply should not apply, that we are, in fact, by going for the uniformity you seek, we are mistreating our military members, treating them, a prisoner has more rights to sue the federal government than does a member of the military. Medical malpractice, among other items.
Yes, a federal prisoner can sue the government for medical malpractice. A federal prisoner cannot sue the federal government for an injury suffered in prison industries.
Well, but you just answered my question. You've tried to parse it. But
I don't
you just
mean
answered, they can sue for medical malpractice.
Yes.
Military members cannot. They can't.
They cannot if it's part of, yes, you're right. Typically they cannot sue, but.
So explain to me the rationale, why you would argue at this point in time, and I've looked at your biography history, that military members should have less rights, which is funny what you said, than a federal prisoner to pursue claims that they've suffered medical malpractice.
Because the federal prisoner does not have the overall compensation
Well, you've just explained it from the perspective of a federal prisoner. What about the perspective of a military member?
A military member has all of the support systems put in place by Congress, whether they're adequate or not, and I think
With all due respect,
they're certainly more generous
With all
than
due
workers'
respect, they don't.
compensation.
I mean, we hear from numerous witnesses here, and I apologize. I had a press conference I had to go to, so my apologies. I have read your opening statements, so please understand it's not just out of the blue, and I'm offended by it. But more importantly, Madam Chair, I believe that Feres needs to be addressed not just for medical malpractice, there are other claims that military members should be able to pursue that, in fact, Feres and the subsequent rulings have prohibited. The idea of uniformity. The other that amazes me is military chain of command. Are you kidding me? We have people being injured because of negligence outside of duties as a combatant. You go to combat, you understand that's the deal. You're in a combat environment. People are taking adverse action, that's the deal. But outside of that, why should they be stripped of their rights while they're sitting on base and someone hits them by a car? Why?
For the same reason that if you are a bus driver for Greyhound Bus and you are struck by a Greyhound bus, you can't sue Greyhound Bus. It's workers' compensation. Now, you could...
Ms. Dr. Sturley, go ahead. Join us, please. I've only got a little bit of time, and I apologize, but...
It's where when something happens at a hospital on base, that's between the doctor and the patient. You know, that information doesn't get back to the chain of command. It can't.
Certainly, hopefully
because
not.
Because of HIPAA. I work as a JAG officer in the Army. It cannot. If it gets back, then the person who has relayed it back will get into trouble. The idea that being able to sue a doctor would affect the good order and discipline of the unit is ridiculous, and it's been rejected by every scholar that I've ever read, to include in the Johnson case. The idea, well, here, I will tell the group this. I've worked for many years as a JAG, as a prosecutor. And what I do is I handle the accusations, typically in the sexual assault case, of a survivor of a sexual assault who's making an accusation against someone who's in the chain of command. Oftentimes, that's against the commander. So here we have a charge made within the unit between a survivor of assault and the commander, and we let those cases go forward. And they don't hurt good order and discipline. So this idea that if I could just finish, so the idea that if we allow a suit between a patient and a doctor that is completely removed from the chain of command would somehow affect the good order and discipline is just ridiculous.
Well, let me, because I've gone well over my time, and I apologize, Madam Chair. I believe that discussing it solely in terms of medical malpractice is inadequate. I believe that since the courts have failed to deal with this effectively, I don't even agree with the logic of the Feres doctrine to believe it.
And I agree with you.
We need to address this on a more holistic basis so that, in fact, our military should not have fewer rights to protect themselves, to recover in circumstances of negligence than do other citizens. And right now they do, and it's morally wrong. So with all due respect, thank you for the additional time. I appreciate it. Thank you for having me be here. I appreciate your service, sir. All of you, I'm sorry.
Thank you, Mr. Mitchell. Mr. Cisneros.
Thank you, Madam Chair. Thank you, Staff Sergeant, Ms. Witt, and Ms. Lip, for being here today. Ms. Witt, I want to ask you a question, just basically based on your testimony. You said you have to apply on an annual basis for you, and I think you said your children biannually for VA compensation to your husband's death. How much do you get from the VA on a yearly basis, if you don't mind me asking?
I can give you an approximate number because I don't have my taxes in front of me. So I believe that there are two different types of benefits. So there's the Department of Defense has the survivor's benefit, which is taxable. That's paid to my children. And then the Department of Veteran Affairs has the dependency and indemnity compensation that is not taxable, nor is it transferable. If I did not have children, say if I was a widow to someone who I had not had children with, I would not be able to receive both these benefits together. To answer your question directly, I believe that my children each get about $450 each from the Department of Defense for survivors' benefits. So you can do the math on that if you want.
And it's taxed.
And now it's increasingly taxed because of the recent tax codes that have gone up, and
Right.
it can be as much as 37% because it's being treated like a trust for a very wealthy child.
Right. So I'll just say it's not very much. So Dr. Sterling, if she was permitted to allow to sue for malpractice, I mean, based on your experience, how much do you think she could have gotten?
From what I've heard here, right? A congressman, 10 million or more. That kind of negligence of the injection of a drug during a routine appendectomy that results in the death of the patient, where there's no explanation for it, it's just the error by the nurse. It would be 10 million or more. And the idea there is that if we're concerned about a sense of the double compensation, if we're concerned that, oh, she could get a claim for, let's say, $10 million and receive from the VA, we do adjustments like this within the government all the time, where we could reduce the amount of her claim that she got from the FDCA by the amount that she receives from the VA. We can make that adjustment. We do it all the time. There's a lot of concern that I've heard from Mr. Figley about the double dipping idea that, oh, there'd be a judgment on a lawsuit and a bit. No, we can make that adjustment. We do it all the time. That was one of the points within the dissent, within the Johnson case, is we were told by Justice Scalia that these kind of adjustments are done on a routine basis. For instance, I work in the National Guard. I've applied for a claim under the VA for a disability. If I get that claim, if I prevail on that claim and I get some kind of a rating, I won't be able to receive my money from the VA until I'm out of the Guard, because otherwise it'd be seen as a double compensation. We can make those adjustments.
Right. And just one other question. I know, Mr. Figley, you had mentioned that one of the reasons for doing this is because all members of the military are treated equal, and to make sure if one person was able to sue for one injury that they had when somebody was sitting in sharing a hospital room with them, would feel mistreated because of that. And you brought up the fact that after 9/11, those individuals received equal payments. That's not true.
They received unequal payments. That was the problem.
Correct. So if they received unequal payments in that situation, why couldn't we do that the same thing for our military folks? They should be. If somebody was treated wrongly and done wrong, why shouldn't they be justified there through the means of being able to sue and get compensation for that mistake and that injustice that was done to them?
Certainly Congress can decide to do that. The disadvantage is that people with similar injuries could receive drastically different amounts. If you're injured in Toronto, you'd get nothing. If you're injured in Kansas, you'd get much less than if you had exactly the same injury in California or New York.
Well, I mean, this is done at the federal. Go ahead, Dr. Sterling.
Well, it's just that happens all the time under the FTCA. Under the FTCA, the way that's written is it's the state law in that state that controls. That happens all the time right now. So why are we using this as an argument to stop a service member from being able to recover when everybody else can?
Right. Yeah. People are allowed to sue now for malpractice in different states, and they're not always going to get the same compensation. There's no equality there.
Right.
So why should we go on and continue? So my time has expired. Thank you very much for.
Thank you. Ms. Escobar.
Thank you, Madam Chair, for bringing us together for this very important hearing. I want to thank all of our witnesses for being here today. I really appreciate your testimony, especially the three of you who have been so deeply, traumatically impacted by what happened to you. Your stories are moving and horrifying and powerful. And Ms. Witt, your sister, is a constituent of mine in El Paso, and she reached out to me, and it's a privilege to get to meet you and all of you, really. My question, and it's somewhat along the lines of what my colleague, Mr. Cisneros, started talking about with regard to compensation. The purpose of being able to sue when you've been wronged is so that you can receive compensation for your pain, for your suffering, for the time and money that you are out as a result of someone's negligence. And Ms. Leip, you mentioned a little bit about the extraordinary amounts of money that you've had to expend personally so you can have a family. And so I'm wondering if each one of you wouldn't mind just very briefly, if you had to put a number on what this has cost you. And I know that it's impossible to put a number on the trauma and the pain and the loss, especially you, Ms. Witt, but the lost income, the amount that you've had to spend on physicians, have you thought about that cost? Have you calculated that before? Ms. Leip, you're nodding, so maybe we start with you and then we work our way over.
I have thought about it because, to Mr. Figley's point that the VA compensation is adequate is completely a misstatement. It's, I receive a disability compensation. It would have taken me 35 months of my disability compensation to actually pay for what I've paid it for IVF. Additionally, my VA compensation there's no accountability or diagnostic code for infertility. There's no diagnostic code for abdominal pain without a cause. So you can't have everything if you don't have a code to claim. I've seen it as not only the money I've spent to have my daughter, the money we would need to spend up to $50,000 probably to have another child if we would pursue adoption. The pain and suffering I feel every day. I take 8 pills a day just to function. As Dr. Sterling said, it would be in the millions because I don't know for how long I'll be able to work. So there's loss of earning capacity. Now, I will say that, yes, I'm a lawyer, so I think about it a little bit more practically. But for me, it's more the non-economic, the pain and suffering, the lost time with my family, the days I have to lay on the couch when my husband plays with my daughter and trying to explain to an almost 2-year-old why Mommy can't play with her. I would say it would be in the millions just for non-economic, and that's something you can never recover through a VA claim.
Thank you.
I don't know if I've ever actually thought of a dead figure. I know when I first filed my wrongful death suit, we had to fill in the block for like how much money do you want to sue for, and I think we came up with just the loss of income and the fact that my husband was 25 at the time. He was approaching the peak of his earning income because he wanted to start going to school, start using his benefits for education, and become a commissioned officer. So the number that we had figured was about $5 million. And to raise a child, it costs $270,000 from 0 to 18. And that barely covers like just their basic care. That doesn't cover extras like going on family vacations or extracurricular activities that they want to do. Nor does it cover their education benefits, even though my children will receive education benefits. And then there's just lots of time with my children. I'm a single parent. Employers are not very forgiving to single mothers. And it's very difficult to find a job and an employer who's compassionate that knows, hey, I can't drop off my kid to daycare this day because they have 104 temperature. And even going to school at the time, professors were not very forgiving of me having to miss days or even bring my sick child into the classroom so that I could complete my degree. And then there's just the severity of the loneliness. I have chosen not to remarry because of this, because I will lose this income that is coming in that I will say has major disparities in it that need to be fixed. So I would say at the time it was $5 million, but I would say, I believe the lawyer at the time that was filing that for me told me that was a very conservative number given what we had gone through as a family and the fact that my husband was essentially brain dead after an appendectomy.
Thank you.
First off, you know, when this illness finally takes me, my wife will join Miss Witt in all of the same things firsthand, so I don't need to repeat any of that. I'm not going to answer truthfully, ma'am. I'm sorry, but I can't put a number on my life. There isn't an amount. I think my kids would probably pay you money to give my life back. But I know over the last year since we've been off post to see specialty referrals down in Tampa, Florida, I mean, we drive our own car. We pay for our own gas. I mean, we were 8, 9, 10 hours, 11 hours in the car every 3 months. Sometimes there was charitable donations that helped us with the gas cards. A lot of times there wasn't. You know, I didn't make the law. I didn't pass the law about how best to handle these things was through amounts of money. But my answer would be whatever amount keeps that practitioner from practicing again. So that's not up to me to decide. That's up to attorneys and lawyers. That's up to you all in Congress to make those decisions about money. But that would be my answer. Whatever stops that person from making that same mistake again, put that number on it, and that'd be my answer.
Thank you, Madam Chairwoman. Thank you all. And my point with that was not to try to measure what a life is valued at, but the fact that you were not able to sue and to get compensation. You are losing more than just through pain and suffering, but there's a real cost to the fact that this is happening to all of you.
Before going to Mr. Christ, I have one question for Ms. Witt. You said that you can't make more than $8,000 a year or you lose your veterans benefit. Could you just clarify?
Yes, that's right. That's about a round figure from the last time that I checked the website. I receive from the Department of Veteran Affairs the DIC payment, which I think is rated for about half of what my husband's retirement would be if he were to have gone about 20 years in the military and retired in full. As I was looking at that, I don't know how often this is enforced, but I do know that there is an earned income restriction right around $8,000 or $9,000, and there's also earned income restrictions with Social Security as well. It's very difficult to find an employer and a job, let alone one that's part-time, that is graded for someone my age. Usually part-time work usually goes to students and to people who are much younger than me and also don't have children. So unless I had found an employer that can meet those restrictions, I've chosen at this time not to work and just be home with my family.
So you would probably have been, you've probably taken a full-time position if you didn't have that restriction on a cap of making no more than $8,000 a year. I mean, it's sort of like, you know, adding insult to injury to have that kind of a restriction. I mean, you have been widowed by malpractice in the military system, and you're now struggling to try and maintain a quality of life for your family, all due to the fact that there was malpractice at a military hospital. So we're going to pursue this more. Mr. Chris.
Thank you. And Chairwoman Spire, I want to thank you particularly for your graciousness in allowing me, as not a committee member, to participate in this hearing today. And so thank you for your leadership and for all the advocates. And to the 3 witnesses who have been subject to this horrific Feres doctrine, I can't thank you enough for your courage in being here today, sharing with us your personal story about how this has affected your lives and your family's lives. It takes a lot of strength to do that, and you're commended for it. And is Sergeant First Class Richard Stayskill, am I saying that correctly, sir?
Yes, sir, Stayskill.
Great. I'm curious, how did you first learn that you would not be able to file a case, in conjunction with what happened to you?
Well, when I first started talking about it with coworkers and just family and everybody else, the thought was, how's your wife going to provide for herself? How's she going to take care of the kids on a single income and all that? I'm not a big fan of the whole thing, but it made sense. Like Ms. Witt was saying, it's a fact. It takes money to raise children and provide for them. So when I started looking into it first, I believe the first place I went was on Womack down to JAG. And that was my first question. I said, hey, I'd like some information about how I would file a lawsuit against a civilian practitioner who works at Womack. And the answer I was met with was, you cannot. And I said, well, why not? I don't know why exactly, but there is a law that says you cannot. That was the best answer he could give me at the time. And then I pretty much just went on from there. So after that, I figured, well, no military JAG was going to help me, so we thought, let's look off post. So my wife, I think we rounded numbers, let's call it 10. She called about 10 offices crying, telling the story over and over and over again, and every time they said, that's a compelling story, but I'm sorry, nobody's going to take your case and nobody's going to listen to you. That was pretty much how that went until we met whistleblower law firm down in Tampa, who they saw the same thing you all are seeing here today, that this is egregious and it needs a fix.
Well, thank you. I found out about your case in particular in Tampa Bay. I represent St. Petersburg and Clearwater on the other side of Tampa Bay from Tampa. And I was with a reporter with our NBC affiliate, Steve Andrews. And, you know, we were at Bay Pines, which is our VA hospital in Pinellas County, and talking about a different story. And he mentioned to me what was happening to you. And he said, well, you know, what do you think about that? I said, that sounds ridiculous. And he said, what do you think ought to be done? I said, we ought to reverse the law. And because of the chairwoman's leadership, we are at that point. But for having found out about your circumstance and your situation, similar to the ones that the other two of you have suffered, we wouldn't be here right now, I don't think. And so the leadership by this chairwoman is extraordinary. It's appropriate to be in this committee. You all are related to military or military yourself. This is the Armed Services Committee. I mean, maybe other committees could weigh in too, and maybe they should. But I just can't thank the three of you enough for being here and your courage and your strength, and God bless you.
Thank you. All right. Do you have any closing remarks you'd like to make, Ranking Member?
Thank you, Chairwoman. And I don't contest that we shouldn't be hearing this as a committee. My problem is not with Chairwoman Spear in having this hearing, because we brought this to the attention of the people who can do something. We need to have this hearing in the Committee of Jurisdiction, which can make a change. And my second point of that is we need to change the things that we can to make it better. Healthcare reform is important, and it's something we can do not to help you, but we can keep it from happening to someone else. And with Chairwoman, I appreciate your leadership in having this, and I'm going to help you push the Judiciary Committee to do their job and have this hearing over there where they can fix this part of the part. So thank you, Chairwoman.
Okay, thank you, Ranking Member Kelly. We have been in conversation with a number of members on the Judiciary Committee. They are very anxious to work with us. We wanted to do this jointly with them today, but they had a markup, so that wasn't something that we were able to arrange. But let me just say that this has been a very powerful hearing. Powerful because the three of you came forward to tell what are truly reprehensible experiences. They deserve to be dealt with the way we deal with cases like that happen to your spouses or your children, or that happen through the VA system, or that happen to a felon in jail. So this has got to be fixed. The fact that this has been on the books for 69 years because the justices, I should say, of the Supreme Court decided to legislate is wrong. And it's wrong that it has gone on as long as it has without the Congress of the United States putting their big people britches on and doing the hard work to come up with a solution that is going to provide justice and that is going to treat service members like others are treated in federal service in a non-combatant setting. So we have lots to do, but you have given us the grist that we will use in order to make sure that we move forward on this. So we're deeply grateful to all of you, and also to you, Dr. Sterling and Mr. Figley, for bringing your perspectives to this hearing. We now stand adjourned.